Welcome to the fourth in the series of webinars focusing on rural disputes. My name is Stephanie Hepburn. I'm an associate in our litigation department. With me is my colleague Elaine Brailsford, and together we are part of our team specialising in rural disputes. Today we are delivering part one of a two-part webinar on access rights in the rural sector. In this part, we'll look at the various private access rights commonly found in the sector and the interpretation and extent of these. Part 2, broadcast on 29th November, will have a closer look at the remedies available when access right disputes arise and also look at public rights of access. In today's webinar, we'll use a semi-fictional scenario which we hope will bring to life the law in this area, as well as giving you a flavour of some of the issues that we have had to advise on recently. So to start us off, Elaine, when do access rights occur?
Well, it's a fundamental feature of Scots law that a landowner is entitled to use his land and do various things with it. However, others may want to take access over the land too, for example, to enable them to access their own property. Or there may be a private access right or a servitude which permits this to be done. A public right-of-way is a right of passage between two places that the public habitually go to, established through a history of use. The right to roam, embodied as a statutory right since 2005, also allows everyone to access most land and inland waters in Scotland for recreational and other purposes. A public right-of-way and a servitude right of access may coexist in relation to the same burdened land.
Looking firstly at servitudes then, Farmer Brown has lived on a farm since he was a very young boy, and he inherited it from his father over 20 years ago. A plan of the farm is shown on the slide there. Area A, outlined in red, is Mr Brown's farm. You'll see the location of Mr Brown's farmhouse, and a conservatory is added to this on the screen. Area B, outlined in pink, was formerly part of Area A, but Mr Brown's father sold Area B off around 30 years ago to a third party. Mr and Mrs Smith have recently acquired the whole of Area B from this third party and have lived there for around a year now. You'll see the location of the main roads on the slide, and also an access path outlined in green, which is also owned by Mr and Mrs Smith. They bought the green area from a different landowner, and it's never been part of Mr Brown's title. And you'll see that this path leads to the local shop and school. Mr Brown is concerned the Smiths want to put up a gate on the access path, which would prevent Mr Brown using it to get to the school and the shop. Elaine, what advice do you have for Mr Brown?
Well, Mr Brown will need to consider whether he has any access rights over this path. Could he have a servitude? There are some basic requirements before a servitude can exist. The first is that there must be two properties, a burdened and a benefited one, or if you're old school like me, a dominant and a servient. These are usually adjacent, but this isn't a requirement. A property can be an incorporeal separate tenement, such as shooting rights or salmon fishing rights. The second is that there must be a pridial benefit, which really means that the servitude must be for the benefit of the property and not simply for an individual proprietor. And thirdly, it's essential that the servitude is not repugnant with ownership. In other words, the use of the burdened property by the benefited one cannot be too onerous on the burdened proprietor's enjoyment of his own property. The last requirement depends on whether the servitude was created before or after the 28th of November 2004. Before the Title Conditions Scotland Act 2003 came into force, the policy of the courts had been to restrict servitudes to those that were known to law. Scottish courts had in effect created a fixed list of servitudes. Now this list included servitudes like ITER, which is pedestrian access, Actus, the right to lead cattle, Via, vehicular access, Overhang, Aqueduct, the right to lead water, Aquahaustus, the right to take water from a river or loch, etc., and Eavesdrop. And before the 28th of November 2004, if the proposed use of land wasn't on that fixed list, or wasn't something akin to the fixed list, then it wouldn't be recognised as a servitude. The reason for this is that the courts were keen to protect purchasers from unregistered rights. This is not true of servitudes expressly created since the 28th of November 2004, because these have to be registered on both the title of the benefited and the burdened property. Therefore, servitudes created expressly in a deed since the 28th of November 2004 are not restricted by this list, and so they can be for any use, provided the use is not repugnant with ownership. And servitudes created by other means, which I'll come on to, still must be known to the law.
But how will Mr. Brown know if he actually has a right of access or not? How are the servitudes created? What would you advise Mr. Brown here, Elaine?
There are a number of ways in which servitudes can be created. The first and perhaps the least common way a servitude can be created is by Act of Parliament. Now, there aren't very many examples of this, but the Forestry Act of 1967 does allow the Forestry Commissioners to create a servitude right of access by order where no formal access exists between a wood or a forest and a road or a railway.
Well, that doesn't have much relevance to the Brown situation here.
No, Mr. Brown is going to need to consider whether he has a servitude created by some other means. The most common way of creating a servitude is by express grant or reservation. Express grant is where a servitude is granted in a deed by the owner of the burdened property, and this could be a disposition, a deed of servitude, a deed of conditions. And as it's a real right in land, formal writing is required. A servitude created by express reservation is where it's reserved by the owner of the benefited property in a disposition granted by him.
Well, unfortunately, a review of Mr. Brown's titles do not disclose any express right in his favour having been granted over at the green area. So in that case, Elaine, I think Mr. Brown will have to consider whether there's been some sort of implied grant or reservation of the rights.
Yes, a servitude can be implied when a property is divided and one side sold to another. This will only be implied where the servitude is necessary for the reasonable enjoyment of the property. And that's a quote from a case back in 1861, Cochrane against Ewart. Now, this is quite a high test. In effect, the courts will normally be looking for evidence of the right having been exercised before the sale. Servitudes can also be created by the converse, that's implied reservation. So this is where, at the time of the split, a servitude is implied to have been reserved over the area being sold. In practice, for implied reservation, the test may be significantly stricter, possibly one of utter necessity, and this is because of the principle that you must not derogate from your grant by impliedly reserving rights.
Well, Mr. Brown's land was never in the same title as the green area, so that would preclude implied grant or reservation of the servitude right of access. So if there's no answer to be found in the title deeds, Elaine, what other possibilities is Mr. Brown going to have to consider?
Well, he might need to consider whether a servitude of necessity exists.
Is that actually a concept known to law?
It's been suggested you may be able to have a servitude simply because of the necessity of the situation, even where the properties have never been on the same title. Now, this concept of servitudes of necessity has been referred to in a number of cases relating to access to landlocked properties. However, in the leading case, which is Bowers v Kennedy, a right of access to landlocked land was held to be a natural civil right which pertains to ownership, as opposed to a servitude right. Actually, we've got a case running in the Court of Session at the moment where the court is being asked to determine whether there is a servitude of necessity, so watch this space.
Well, in Mr. Brown's case, using this path outlined in green to go to the school and the shops and back is just the most convenient way for him. There are other ways for him to get to and from his land and to and from the shop and the school. So the doctrine of necessity doesn't really help us here. Is there anything else he should be considering?
Theoretically, it's possible to constitute a servitude through acquiescence, although there's really very few cases on this. Acquiescence is often referred to as a last resort in relation to the creation of a new servitude. In theory, it could occur where great cost is incurred by one party or something is done that cannot be undone. In both cases, this would need to be with the knowledge of the potentially burdened proprietor, who would have had to have stood back and done nothing. The few cases in this area tend to relate to water and water supplies, though.
So again, that's not much help to Mr. Brown. Should Mr. Brown be thinking of positive prescription?
Yes, that's right. Where there's been actual use and possession of a servitude exercised as of right for 20 years, a servitude right may be created by prescription. The use must have been exercised continuously, openly, peaceably, and without judicial interruption. This could be based on a defective deed, or more commonly just on use. The requirement for this to be exercised as of right has been a point which the courts have really had difficulty in defining. But the generally held view is that this is a requirement for the possession to be adverse as opposed to exercising a right with the agreement of the burdened proprietor. Therefore, the right must not be able to be explained away in another manner, such as they've had a license to occupy or a contractual right. The possession will not be adverse, though, if it's been with the tolerance of the owner.
Well, on speaking to Mr. Brown, he's able to confirm that access has been taken for him well in excess of 20 years, which is why he is so sure that it exists. Mr. Brown, as we heard, inherited the farm from his father over 20 years ago, and he has walked down that path every morning to take the family dog, Jessie, for a walk. He has also used the path at various times regularly over the last 20 years to take all of his children to school and to buy provisions from the local shop. He has fond memories of his father taking him to school using the same path over 40 years ago. Mr. Brown wants to throw the book at the Smiths. He wants to see them in court. Elaine, what would you advise Mr. Brown to do next?
Well, not necessarily go straight to court, because that can be a risky and expensive business. First of all, he needs to talk to the Smiths, setting out the right, calling on them to rethink their plans to fence off the land. If that doesn't work, the next step would be to perhaps send a lawyer's letter formally requesting this. I'd caution against self-help remedies. That can be dangerous, particularly if he causes damage by doing so and then puts himself in the wrong.
Well, in our case, sense prevails. The Smiths are not rash and they're keen to avoid conflicts. They do realign their fence and peace is restored, but not for long. The Smiths decide that a disused farm steading on their land has a lot of character and it might make a good restaurant. They decide to convert this steading. Access to the restaurant is taken over a secondary access road on Mr. Brown's land, which you'll see on the slide there. Mr. Brown is absolutely incensed. He claims that hundreds of cars are passing up and down the access every day and night and parking on this road too. It's not just tarmac, it's gravel and mud. Mr. Brown knows the Smiths have got a right to use this road, but can all these cars park on it and use it? What about maintenance? The access was not meant for this level of traffic and it's not standing up to it. It is in dire need of repair. The Smiths tell Mr. Brown they do want to repair the roads, but they also want to improve it by tidying it up and making it a proper tarmac road. Mr. Brown is not keen on this at all. Surely that would encourage even more traffic on the roads. He wants to block off the access altogether. In fact, he's put up a gate at the entrance from the public road. Elaine, what's your advice here?
Well, we'd need to start by considering the extent of the access right, and then whether or not the Smiths are allowed this level of traffic. Then we need to look at whether they can tarmac the route and whether they have a right to park on it. So there are a number of considerations there. And in answering all of these questions, we'd need firstly to construe the express terms of the deed. Now, in this case, the deed provides a servitude right of vehicular access and egress at all times over and across the retained property by way of the road identified in red on the attached plan.
Well, what does that tell us?
Well, the way a servitude is interpreted depends on how it was constituted. If it had been created by prescription, the interpretation of it would be based on the doctrine of tantum prescriptum, tantum possessum, i.e. the extent of the right depends on the extent of the possession. However, here it was created in a deed, so the wording of the deed provides the extent of the servitude.
And what sort of approach do the courts take then when they're interpreting the servitude?
Because the servitude is a limitation on freedom of ownership, the courts do construe them quite strictly, and there is a presumption in favour of the burdened property being free from restrictions. However, if it's not a question of taking the most strict and narrow construction possible, the courts will take a purposive approach, taking into account the interests that the parties intended to protect when the servitude was created. The general principle is that the servitude must not be extended beyond what would have been within the reasonable contemplation of the parties at the time.
But what if the word indeed is ambiguous?
If there's an ambiguity, the court will favour the construction which is least burdensome to the burdened property. If the deed does not specify essential details, such as the root of a servitude, the court can look at the surrounding circumstances at the time of the grant and subsequent possession to determine the extent of the right. However, if the wording is clear, they will be given reasonable and fair construction.
Well, looking back at the servitude we have in this case then, it does seem quite wide. Does that assist us in answering Mr. Brown's questions? Are the Smiths allowed to have this volume of traffic pass along the access road? Can they tarmac the route? Can the Smiths park on Mr. Brown's land? What about this gate he's put up?
We have a very basic express servitude of vehicular access here. Nothing in the express words restricts the volume of traffic. The deed is silent on repairs and improvements. There's no mention of a right to park, so just looking at the four corners of the deed is not very illuminating.
Well, what else can we do to help Mr. Brown? Where else can we look for guidance on all these questions?
At common law, the Smiths have certain rights and Mr. Brown has certain obligations in relation to the access road and the gate, and we would need to consider if the parties have complied with these.
So if we look firstly then at the repairs to the road the Smiths want to do, who has the obligation to repair the roads?
As was said, there are no express provisions in the servitude which oblige either Mr. Brown or the Smiths to maintain or repair the access road, and in the absence of that, Mr. Brown is not required to carry out repairs to an access route on his land.
So does that mean the Smiths are allowed to repair it? Are they entitled to, or are they obliged to it even?
The Smiths are entitled to enjoy the servitude to its full extent and carry out physical acts on the access road to help them achieve this. So this would cover repairs, but it's a right, not an obligation. If the access road becomes such that it's not usable by the Smiths, the obligation to repair it will generally fall to Mr. Brown, because he has an obligation not to derogate from his grant. If any damage to the access road has been caused deliberately or negligently by the Smiths, they would be liable. Of course, in modern deeds, repair and maintenance obligations are usually covered off.
Okay, so it looks like it's likely the Smiths can repair the access roads. What about the improvements though? Can the Smiths do that? Can they tarmac it?
Ancillary rights may be implied to a servitude if the right is necessary for the convenient and comfortable enjoyment of the servitude, and if it was within the reasonable contemplation of the parties at the time the servitude was created.
So could the Smiths argue this covers the improvements to the road they're proposing?
Yes, here we have an express right which is silent as to maintenance and improvement of the road. So ancillary rights can be implied. The Smiths may be able to upgrade the road, provided that the nature of the road is not changed and there is not a material increase in the burden on the burdened property. There have been cases where the benefited proprietor has been allowed to put hardcore or gravel on an existing road surface, which did not increase the width of the road or materially change its height, or to put a metalled surface on the road where this was reasonably necessary for the purpose of exercising the servitude right granted. So in the Smith's case, It really depends on the purpose of the servitude and the underlying circumstances.
Well, upon further investigation, it comes to light that when Area B was sold from Mr. Brown's father, it was sold on the understanding it would be developed for housing. Outline planning permission had been obtained for 100 houses. Despite Mr. Brown claiming that hundreds of cars are passing down the road to the restaurant each day and parking on the roads, in reality it's quite a small restaurant, and perhaps 20 to 30 cars are accessing the road and parking there each day, not quite the hundreds Mr. Brown claims.
In that case, given the amount of traffic that was anticipated to serve 100 houses, and the fact that a gravel road clearly cannot withstand that level of traffic, it was probably always contemplated that the road would be tarmacked, and it's therefore arguable that the Smiths are entitled to improve the road in the way that they have proposed.
What about this gate? Has Mr. Brown got an obligation to remove the gate?
Well, essentially, Mr. Brown's obligation is to respect the servitude. He shouldn't derogate from the grant of the servitude, and he shouldn't take steps which interfere with the proper exercise and enjoyment of the servitude. Mr. Brown will therefore be required to remove the gate, or at the very least provide a key, as the gate is an obstruction which is preventing the Smiths from taking access. Although I have to say, if it was contemplated that constant traffic would have been using the access road to access 100 houses, it may be thought unreasonable for everyone to have to stop and unlock a gate.
Well, Mr. Brown isn't really happy you'll have to remove the gate or perhaps give a key just to allow all those cars to drive over his road to access the restaurant. Are the Smiths allowed to increase the volume of cars on the road like that?
The Smiths are obliged to comply with 3 legally implied conditions. The first is that a servitude must be exercised only for the benefit of the benefited property. So the benefited proprietor cannot exercise the right for the benefit of another neighbouring property they might also own. And the leading case on that is Irvine Knitters against North Ayrshire Cooperative Society in 1978. And that case held that the benefited property cannot be used as a bridge to get to other land which is not part of the benefited property. And this is something to watch out for in estate titles and larger properties where different parts may have been acquired at different times and or from different people. It's often overlooked, which can have significant consequences.
That doesn't arise here, though.
No, the next legally implied condition is that the exercise must be civiliter. Now this means that the right must be exercised reasonably and the minimum possible burden imposed on the burdened property consistent with the full enjoyment of the right.
And is that breached because of the number of cars on the Browns' property?
Perhaps, but it's not just necessarily a question of civiliter. The final legally implied condition is that the exercise of the servitude must not cause an unwarrantable increase in the acceptable burden on the burdened property. Unwarrantable means not permitted by the servitude in question. That is, any increase from the extent of the servitude when it was created is not allowed. So, you have to look at what was in the reasonable contemplation of the parties at the time the servitude was created.
I don't think that's really clear from the very general express right we have here, which simply says that there is a servitude right of vehicular access and egress at all times over and across the retained property by way of the road identified in red on the plan. What do we do in this situation? Does the fact the Smiths have changed the farmstead into a commercial restaurant matter?
A change in the type of use made of the benefited property is not in itself an increase in the burden on the burdened property. The servitude can still be exercised for the new use.
So, changing the access road to be an access road to a commercial restaurant as opposed to a farm building or steading is not necessarily of itself an unwarrantable increase in the burden.
Exactly. A change in the type of thing passing may be an unwarrantable increase in the burden. For example, normal farm traffic changing to, say, 40-ton forestry vehicles may be an unwarrantable increase in the burden. It is clear that a servitude for pedestrian access cannot be used for vehicular access. However, modern versions of a previous use are permitted, so, for example, cart and carriage roads can now be used for cars.
But here, there's no change in the type of thing passing, just the volume. Does the increase in the volume of traffic amount to an unwarrantable increase in the burden then? The servitude itself does not have any restrictions as to the volume of traffic.
Whether the Smith's increased use is an increase in the burden is really a question of scale. This is a common issue in practice in relation to access, and the law is obscure here, and each case must be assessed on its own facts. Just because the express servitude in favour of the Smiths over Mr. Brown's property is wide and granted without any limitations doesn't mean that there is no limitation at all on the volume of the traffic using the road. The courts will look at what was in the contemplation of the parties when the servitude was created.
We found out earlier that when Area B was sold, it was on the understanding that it would be developed for housing. Presumably then, the Smiths are going to have an argument it would have been in the contemplation of the parties at that time there'd be this amount of traffic up and down the access routes.
Yes, and fortunately for Mr. Brown, I think that will be the case. I think it's unlikely that the increase in cars in this situation would be an unwarrantable increase in the burden.
What about the parking then? Can Mr. Brown do anything about that?
Well, we need to think about whether the Smiths have a servitude right to park or whether they can argue that the right to park is ancillary to the right of access. In the case of Moncrieff against Jameson in 2007, the House of Lords held that parking could be ancillary to a servitude right of access. The majority of their lordships, when considering the facts in that case, thought that car parking could exist as a servitude on its own, and the case of Thomas and Thomas against Smith, which is a recent case in 2016, has actually put that beyond doubt. In the Thomas and Thomas case, the area of land owned by Johnson, the pursuer, was used for parking caravans. The defender's land was a long, narrow, empty strip, which lay immediately adjacent to this parking area. And Johnson had used the narrow strip as additional parking for all kinds of vehicles for many years, including articulated lorries and arcade amusement equipment and rides. And Johnson claimed that a servitude right of parking had been established. Now, the sheriff in this case made reference to the comments made by their lordships in the Moncrieff case, that it was, quotes, but a short skip in logic to conclude by analogy with the ancillary right recognised in that case that an independent, freestanding servitude right is at least similar in nature thereto. So as a result, a servitude right of car parking is now included as a recognised and known servitude in Scots law.
Well, Mr. Brown is very concerned to hear this. He does not want all these cars parking on his land.
Yes, but even though the Thompson case recognised a servitude right to park, the servitude still has to be created in some way. Here, there is no right to park created expressly in the deed. In the Thompson case, the pursuer had parked on the defender's land for a period in excess of 20 years, and the servitude had thus been established by prescription.
Well, here the Smiths have only parked on the customers have only parked on Mr. Brown's land for a year or so, so no servitude of car parking can arise by prescription. Is that right?
That's right, and Mr. Brown should take steps to ensure that the Smiths or their customers' parking on the land is challenged such that the Smiths will not be able to satisfy the test for creating a servitude by prescription, and that is, of course, continuous, open and peaceable use as of right and without judicial interruption for a period of 20 years.
So if the Smiths can't establish a prescriptive right, could they argue there's a right to park ancillary to the right of access?
That's a possibility. However, in Moncrieff v. Jameson, the case which established that parking could be an ancillary right to an access right, the geographical and physical location was very unique. The subjects were at the edge of a cliff, and the court said that if there was no right to park, the access right would essentially have been defeated. We don't have that here. The access right can clearly still be used without the right to park.
That looks positive for Mr Brown if the Smiths are unlikely to have an ancillary right to park on Mr Brown's land and they haven't got a prescriptive right yet. But on the not so positive side, the Smiths appear to have a valid and enforceable servitude right of access, vehicular access, which Mr Brown can't interfere with, and if he does, he may face legal action himself. He also needs to remove the gate. The increased flow of traffic is unlikely to amount to an unwarrantable increase in the burden on the access roads, in this case, given what we know about the development intentions of Area B. It's likely the Smiths have a right to repair and, to a limited extent, improve the access roads. Given what we know about the development plans for Area B, they also have a good argument in favour of being allowed to upgrade the roads. Mr Brown is very keen to take action to prevent the Smiths customers from parking on the access roads. In part 2 of this webinar, broadcast on 29th of November, we'll explore the remedies available to Mr Brown to achieve this and also move on to chapter 2 of Mr Brown's story when he discovers ramblers exercising their right to roam on a path that runs very close to his bedroom window. That's us for today. Thank you all for joining us. Hopefully you'll all have the link to sign up to part 2 on 29th November, but if anyone has any questions in the meantime, please feel free to ask us now using the chat facility on your screen, or drop us an email. Our emails are on the slide there. Okay, no questions so far. You have got our contact details, so hopefully we'll hear from you. Otherwise, we will do part 2 on 29th of November. Thank you.
Thank you.